डायरेक्टर साहब के साथ, तो वो चर्चा हो रही थी, तो बोले कि अमित जी को जोड़ते हैं। हम बोले हाँ अमित जी को जोड़ लीजिए, ज्यादा अच्छा रहेगा।
जी जी जी, हाँ आप लोगों से बात करने का मौका मिल गया इस समय। हेलो
all participants and learned speakers, आज के वेबिनार का विषय है मैकेनिज्म ऑफ प्ली बार्गेनिंग इन क्रिमिनल जस्टिस सिस्टम इन द कंटेक्स्ट ऑफ कोविड-19। तो मैं सादर आमंत्रित करता हूं सर्वप्रथम इस कॉलेज के डायरेक्टर जयंत बाबू को। प्लीज सर।
विनाश।
Honorable Mr. S.K. Misra, President of the college.
Can you hear me, Vinas?
Our Secretary,
Hello.
Dr. Manjula Misra.
Hello, am I audible?
Dr. Salim Javed, Head PG Department of Law, Patna University. Dr. Rakesh Kumar, Assistant Professor, Government Law College, Alwar, Rajasthan. Dr. Avidas Kumar, Assistant Professor, School of Law, Christ deemed to be University, Delhi, NCR. My younger brother, Dr. Amit Kumar Srivastava, Deputy Dean, Faculty of Legal Study, Mewar University, Chittorgarh, Rajasthan. My another younger brother, Professor Dr. Subhash Chandra Roy, Dean Research and Development, Chanakya National Law University, Patna. Dr. K.K.N. Tiwari, Principal. Mr. B.M. Azad, Vice Principal. Dear teachers, staff, students, and dear press and media persons. Dear distinguished guest speakers and participants, it is a great pleasure for me to welcome you here in this webinar. I am Jayant Kumar, Director of the college. Today, we are gathered here to talk about a very relevant topic of this time, mechanism of plea bargaining in criminal justice system in the context of COVID-19 challenges. In India, the concept of plea bargaining was brought about by way of the Criminal Law Amendment Act 2005, which is introduced in Chapter 21 Criminal Procedure 1930. The act was made enforcement from 5th July 2000. The concept of plea bargaining has been borrowed from the Constitution of USA. It was first suggested by the 142nd Report 1 of the Law Commission of India as alternative step to tackle huge areas and loopholes of the criminal cases in the courts. We have expert panel of speakers and legal luminaries who can throw light on the topic in detail. Today, I must mention about the management of the college to encourage us to organize seminars from time to time and also webinars under COVID-19 pandemic for the larger interest of the students of this college. This is the 4th webinar organized by us, 1 international and 3 national, all with the great luminaries and scholars in the field of law, which were made possible with the advancement of technology also. I also must mention about our students who are always keen to extend their knowledge through webinars, as a result of which they always join webinars in large number, which shows their hunger to acquire knowledge. Today, on this great occasion, I again welcome our distinguished speakers and all the participants, and I am sure we all will benefit from their vast experience in the field of law, and I hope this webinar will reflect some of the topical issues and offer useful insights. I thank each one of you once again. Thank you.
थैंक यू सर वेरी मच। अब हम सादर आमंत्रित करते हैं डॉक्टर सलीम जावेद साहब को, हेड पीजी डिपार्टमेंट ऑफ लॉ, पटना यूनिवर्सिटी। डॉक्टर सलीम जावेद साहब।
यस सर। सर मुझे सुन सकते हैं?
सर सुन रहे हैं सर।
यस सर, थैंक यू सर। Dear friends, to begin with today's national webinar organized by Sri Krishna Jubilee Law College on a topic which is not even in the priority list of those who are responsible for the enforcement of the same. So, first of all, I would like to extend my sincere thanks in favor of senior but very kind-hearted Sri Jayant Kumar sir, Director SKJ Law College, for organizing this one-day webinar on such a relevant but unfortunately ignored subject of Indian criminal justice system. I also extend my sincere love and affection in favor of other panelists, especially in favor of my students like Rakesh and Avinash Acharya ji and Bimal ji. Finally, I would like to appreciate the complete team of Jain sir for organizing this webinar and giving me this opportunity to connect with you all. Thank you all, especially the students who are participating in large number in this webinar. They also deserve a special appreciation for participating in this webinar. Friends, as a first speaker of today's webinar, first of all, I would like to discuss the very basics of today's special topic, plea bargaining in the context of COVID-19 in India. Friends, Indian concept of plea bargaining is inspired from the United States doctrine popularly known as NOLO calendar, which literally means I do not want to contest. In short, we can say that in plea bargaining, the accused plead guilty and said not to contest the case. In return, prosecution agreed for the reduction of a charge from a serious charge. Friends, here I would like to quote the definition of plea bargaining given in Black's Law Dictionary in following words: the process where the accused and the prosecutor in a criminal case work out mutually satisfactory disposition of the case subject to court approval. The other definition which I would like to quote here is the definition given in Oxford Dictionary. According to Oxford Dictionary, plea bargaining is an agreement between prosecutor and defendant whereby the defendant pleads guilty to a lesser charge in exchange for more lenient sentence or an agreement to drop other charges. In short, again, we can conclude that plea bargaining can be described as an agreement that takes place at the pre-trial stage wherein accused pleads guilty in lieu of some concessions given by the prosecutor, but may occur at any time before a judgment is rendered. Friends, we all are very much aware about the fact that what is the condition of Indian courts, especially from the point of view of pendency of the case. We all know that crores of cases are pending before one or the other courts within the territory of India. And the government of India, just to curb down the large number of pending cases within the different courts within the territory of India, finally, uh, through its 142nd Law Commission report, started to work out for the accepting the concept of plea bargaining in case of the criminal justice system in India. In 2005, finally, by one or the other painstaking efforts on the part of the different government agencies, in 2005, through Criminal Law Amendment Act, plea bargaining has been introduced, which came into existence from July 5, 2006, which the introduction of a new chapter 21A incorporating sections 265A to 265L in the Criminal Procedure Code. From 2006, what actually important is to discuss here is the situation that whether the change in the or whether after the incorporating the concept of plea bargaining in the Indian criminal justice system, which was not earlier allowed, whether any change we witnessed or not in case of the reduction of the large number of dependencies before the different courts in India. If you analyze the data from 2006 to 2020, you will be surprised to know that Indian courts were not aware somehow about the existing provisions given under section 265A to 265L, as a result of which no basic impact can be seen on the tendency of the suits before the different courts within the territory of India. Friends, I just want to give you a reference on the basis of which you can analyze the importance of the plea bargaining in USA. One of the district judge was participating. All the participants, please requested to switch off your mic and video camera, please. Otherwise, it is creating nuisance. So I was just telling you about an reference which was given by a district judge who was allowed to participate in a training program, and he was in America in the process of that training. He quoted that in a year, in his jurisdiction in which he was there for the training program, in a district court, in a year, 3,000 cases were generally filed. He was quoting on the basis of the report of so many years, and he let me know that out of 3,000, approximately 2,700 cases were disposed of just by referring the plea bargaining. Only 300 cases were contested between the accused or the defendant. This is the importance of the plea bargaining. But unfortunately, in Indian context, we are not in a position to give any good references on the basis of the plea bargaining incorporated in the different chapters of the CRPC. So, if we club these two concepts together, then we may be able to analyze that if we were being able to have the effective plea bargaining incorporated in the Indian criminal justice system, then in case of COVID-19, we may be able to curb down, the pain and sufferings of both the parties, the plaintiff and the defendant. You know that from last so many months, the maximum courts were either in switch off mode, or if they are working, they all are not working on regular basis. So if this concept of plea bargaining were incorporated effectively in the Indian criminal justice system, then we might have been able to curtail the pain and sufferings of the different litigants involved, either in the form of the accused or in the form of the defendant. So finally, I would like to conclude again by extending my thanks in favor of Jan sir for giving me this opportunity to connect with all of you. Thank you very much. Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
सलीम जावेद साहब, थैंक यू वेरी मच।
Welcome, sir.
आमंत्रित करते हैं डॉक्टर राकेश कुमार जी को, असिस्टेंट प्रोफेसर, गवर्नमेंट लॉ कॉलेज अलवर, राजस्थान। डॉक्टर राकेश कुमार।
हेलो हेलो,
Yes,
हाँ,
sir, you are
बोलिए।
audible, sir.
गुड मॉर्निंग टू ऑल ऑफ यू सर, और आप सभी को
Good morning,
नमस्कार।
sir.
Good morning, sir.
Namaskar, sir.
Thanks for
Sir,
giving
sir.
me this opportunity. And today's topic is the mechanism of plea bargaining in criminal justice system in the context of COVID-19. निश्चित रूप से आज जो वैश्विक कोरोना महामारी है, उससे पूरा ही जीवन अस्त व्यस्त हो गया है, और ऐसे में जो हमारी न्यायिक व्यवस्था है, न्याय प्रणाली व्यवस्था में जो केसेस रोज आ रहे हैं, उस केसेस को सुनने में, समझने में भी बहुत इससे अलग कुछ नहीं है। वो भी बहुत इस न्याय व्यवस्था भी इस कोरोना महामारी में प्रभावित हुआ है। The lockdown due to COVID-19 has impacted one and all. The courts are no exceptions to it. While many courts are not working, yet some others are hearing only urgent and important matters. Even the Supreme Court has been hearing important cases through video conferencing. The Supreme Court has ordered the state to form high-powered committee to evolve measures that will solve the problem of the under trials contracting the virus. The court further suggested that the under trials evolve in cases that prescribe a maximum of 7-year punishment may be released on the interim bail for a suitable period to ensure that they do not contract the virus while in prison. अब हमारे यहाँ जो जेलों की व्यवस्था है वो भी किसी से छिपी हुई नहीं है। हमारे यहाँ जो जेल है उसमें जितनी जगह है उससे कई गुना ज्यादा हमारे यहाँ तो कैदी बंद हैं, और इस कारण से जो कोरोना महामारी है उस समय जेलों में भी वायरस न फैले, और जेलों के हालात को ऐसा देखते हुए लगता है कि देखते हुए जो हमारे जो विभिन्न अदालत हैं उन्होंने कहा था कि अभी हाल जब मार्च में कोविड-19 के लिए जब अनाउंस हुआ कि ये वैश्विक महामारी है, तो वैसी स्थिति में विभिन्न अदालतों ने कहा कि इसको कैदियों को अस्थायी रूप से रिहा कर दिया जाना चाहिए, ऐसा निर्देश भी दिया। और इस निर्देश के बाद कुछ केंद्र शासित प्रदेश को उच्च स्तरीय न्यायालय ने सुझाव दिया था, और उसमें एक वैसे दोषी को पैरोल पे या अंतिम जमानत के लिए रिहाई पे करने पे विचार किया जाना चाहिए जिसकी 7 साल से कम उम्र की सजा है। शीर्ष अदालत के निर्देश के बाद मध्य प्रदेश, उत्तर प्रदेश, महाराष्ट्र, पश्चिम बंगाल, हिमाचल प्रदेश, गुजरात ने भी ऐसा करने की शुरुआत की, पहल की थी, लेकिन हालांकि ये बहुत ठोस उपाय नहीं है। आज हमारे विभिन्न न्यायालय में करोड़ों मामले ऐसे हैं जो लंबित हैं, और जिसका साधारण परिस्थिति में भी निपटारा, जो जनरल परिस्थिति हमारी है वैसे में भी निपटारा करने में कई वर्ष लग जा रहे हैं, और कब तक लगेंगे, कितने वर्ष लग जा रहे हैं। और कोविड-19 जैसी बीमारी, महामारी आ गई है, तब तो न्यायालय का बोझ और भी कई गुना ज्यादा बढ़ने जा रहा है, और कितने और न ज्यादा नए मामले लंबित हो जाएंगे और उन्हें सुनने में कितना समय लगेगा। कहते हैं कि justice delay, justice denied. So it is the need of the hour to take initiative to reduce the load of our courts in disposing of cases to ensure they would not be under a burden of cases when the courts open. Here the concept of plea bargaining may come handy. The Criminal Procedure Code provides for the procedure for plea bargaining for certain types of offenses. A new chapter, that is chapter 21A on plea bargaining, has been introduced in the Criminal Procedure Code. It was introduced through the Criminal Law Amendment Act 2005, which was passed by the Parliament in its winter session. It became effective from 5th July 2006. Was originally plea bargaining is an American concept. Its origin can be traced back in America during 19th century. Over the years, plea bargaining has emerged as a prominent feature of the American judicial system. Plea bargaining refers to persons charged with a criminal offense negotiating with the prosecution for a lesser punishment than what is provided in law by pleading guilty to a less serious offense. It is common in the United States and has been a successful method of avoiding protracted and complicated trials. As a result, conviction rates are significantly high there in America. In primarily involves pre-trial negotiations between the accused and the prosecutors. It may involve bargaining on the charge or in the quantum sentence. It is seen as a win-win position for all the parties. As the prosecution has a certain conviction on the record, the defendant is provided a more lenient sentence than the risk of a higher one at trial, and the judge is free to move to other cases and disputes to resolve. There are different types of, we can say there are different types of plea bargaining, like sentence bargaining, charge bargaining, fact bargaining. In sentence bargaining means motive of this to get lesser sentence. Defendant agrees to the charge and in returns get a lighter sentence. And in charge bargaining, defendant agrees to plead guilty to a lesser charge in return of dismissing of greater charge. And what in fact bargaining, defendant agrees to stipulate certain facts. In return, he prevents other facts to enter as evidence. Provisions in CRPC, section 265A to 65E. Section 265 mentions that the plea bargaining, according to section 265, the plea bargaining shall be available to the accused who is charged with any offense other than offenses punishable with death or imprisonment or for life or of imprisonment for a term exceeding to 7 years. And request for plea bargaining can be initiated only at the stage of cognizance of the offense by the court. Offenses involving socio-economic conditions of the country or offenses against women and children below 14 years of age are excluded from the review of plea bargaining. And what section 265E mentions, section 265 of the CRPC said that court can either release the accused by giving admonition on releasing on probation under the provision of section 360 of the Code of Under the Probation of Offenders Act 1958 or under any other legal provisions in force or punish the accused passing the sentence. The court can order the disposal of cases in criminal as defined in section 265A, ensure that the burden on the judiciary is reduced along with the initiative for accused to admit their guilty by way of doing away the pain of going through prolonged stay inside the prison and also the trial procedure. अब हमारे यहाँ जेलों की व्यवस्था क्या है, ये हम लोगों में से किसी से छिपी हुई नहीं है. जेलों में जितनी जगह है उससे कई गुना कैदी हमारे यहाँ जेल में बंद हैं, ये हम सब लोग जानते हैं. तो here the history, what is the history of plea bargaining? more than 90% of the criminal cases in America are never tried. The majority of the individuals who are accused of a criminal give up their constitutional rights and plead guilty. A case in India, the case Kasambi Abdul Rahman Bhai Sheikh versus State of Gujarat. In this case, the court held in the case that plea bargaining is a case against public policy, and it pollutes the pure front of the justice. The court had challenged the morality of plea bargaining, and it also regretted the fact that magistrate has accepted the plea bargaining. And the other case, Muralidhar Mehra Loya versus the state of Maharashtra, the Supreme Court did not encourage the concept of plea bargaining at that time. They believed it be a formal inducement, the enormous power in hand of corruption and of justice. It held that plea bargaining introduced upon the society interested public mood. This is the current burden of pending cases in various courts in our country is too huge. कोरोना संकट के समय में हमारे देश में विभिन्न केसों की संख्या बढ़ रही है, इतना जो बोझ बढ़ रहा है, ऐसे में प्ली बार्गेनिंग एक अच्छा उपाय हो सकता है कि उससे उस केस को कम किया जाए। अंडर ट्रायल लिजनर्स हैं, अब्यूजर्स के बीच वीडियो कॉन्फ्रेंसिंग करके प्रीत और जो वकील हैं वो 265B के अनुसार आपस में सहमत हैं और तरह से एक व्यवस्था की जा सकती है बार्गेनिंग के थ्रू। जैसा नटवर मामले में कहा गया था कि बार्गेनिंग से कानून उद्देश्य तेजी से शीघ्र न्याय प्रदान करना है, शीघ्र न्याय प्रदान करना है। हमारे यहाँ जो कोर्टों की सजा है वो किसी छिपी हुई नहीं कि क्या है। तो हम देखें कि in many successful cases with plea bargaining and this helps in reducing number of cases pending in court। और ऐसा मानना है कि प्ली बार्गेनिंग 80 से 90% तक के कम किए सकते हैं। प्ली बार्गेनिंग की वजह से बहुत सारे मामले निपटाए जा सकते हैं और ये दोनों ही तरह जो डिफेंडेंट हैं और जो प्रोसेसर्स हैं उनके फायदेमंद है। लॉन्ग स्टैंडिंग डिस्प्यूट कैन बी इजीली रिजॉल्व। It helps in reducing the record of less serious offense in the court, and this can go good for the accused he is convicted in the future। और दूसरी अगर हम देखें अदर साइड, the reason for introducing plea bargaining are the overcrowding jails, high rate of acute tort of trial fears। तब कुछ और करना है जिसके कारण बार्गेनिंग में लाना है, but the main reason behind all this is delay in trial process। बट हम डिसएडवांटेज की थोड़ी सी बात करें कि क्या एडवांटेज होते हैं, तो कैसा कि डिमोलाइज इंडिपेंडेंट जुडिशियल ऑथोरिटी, द रोल ऑफ विक्टिम इन प्रोसेस, affect corruption which ultimately defect the purpose of plea bargaining, right of convict in Article 20 of our Indian Constitution। लेकिन जो फिलहाल का वक्त है, जो का समय है, ऐसे भी जो हमारे यहाँ की जो न्याय व्यवस्था में पेंडिंग केसेस में पड़े हैं, तो अभी के अगर वीडियो में देखे के वक्त देखो प्ली बार्गेनिंग अभी की जरूरत है। पहले पे ही लाखों करोड़ मामले लंबे हैं और कोरोना मामले महामारी है, तब तो इसकी व्यवस्था जरूरत और ज्यादा पड़ जाती। जब हम जो हम जुडिशियल प्रोसीडिंग है, न्याय प्रणाली का जो पूरा मैकेनिज्म है, ये कहें कि न्याय प्रणाली व्यवस्था जल्द न्याय देने की व्यवस्था नहीं करते हैं, तो हमें इस पूरी मैकेनिज्म को डेवलप कर लेते हैं कि व्यवस्था में हम हार जाते हैं, तब तक हमें कुछ डिसएडवांटेज हैं, इसके आधार पे हम इसको रिजेक्ट नहीं कर सकते, हमें इसे करना भी नहीं चाहिए। और मतलब समथिंग ऑन द बेसिस ऑफ डिसएडवांटेज इज नॉट जस्टिफाइड। इसलिए इस वक्त की जरूरत है कि प्ली बार्गेनिंग को बढ़ावा जाए, और जब हम अपने मैकेनिज्म को डेवलप नहीं कर, हम प्ली बार्गेनिंग को दे सकते हैं और बहुत केसेस के लोड को कम कर सकते हैं और कोरोना महामारी से केसेस की संख्या बढ़ रही है, उसको भी हम कम कर सकते हैं। थैंक यू। थैंक यू।
Thank you, sir.
थैंक यू सर।
Thank you, sir, very much.
Thank you, sir.
स्पीकर डॉक्टर राकेश कुमार जी। अब हम सादर आमंत्रित करते हैं डॉक्टर अविनाश कुमार जी, असिस्टेंट प्रोफेसर, स्कूल ऑफ लॉ, क्राइस्ट डीम्ड यूनिवर्सिटी, दिल्ली।
Hello.
Please.
Thank you, sir. Am I audible?
Yes, sir.
Yes, yes.
Okay. Okay. Thank you, sir. Thank you
Hello.
for the invitation.
Roger sir, तो ना bathroom जाए।
Could you please everyone mute yourself? Mute your audio and video both for the better connectivity. Otherwise, it's not possible to listen properly. So it's my humble request to all of you, just mute yourself, because we have very less time, only 15 minutes sir has given us. So first of all, thank you SKJ Law College, thank you Jain sir to invite me. And this topic, this plea bargaining topic, is very near to me, sir, because I have done a research on plea bargaining, and this plea bargaining, that's chapter 21A, which came in 2005, that's very near to me, because it comes in CRPC, and CRPC is my favorite subject also. Coming to the topic, this mechanism. So the mechanism of plea bargaining, as if you call any advocate who has filed a petition for plea bargaining, an application for plea bargaining, he will tell you in detail about this mechanism. But still, I will try my best to justify this topic, sir. Now, coming to the this topic, before coming to the topic, as our previous speaker Salim sir is my respectable sir, because he is my he was my HOD when I was doing my PhD in Patna University. So aapko pranam sir, first of all. Then Rakesh sir also, the previous speaker, he is also very respectable to me and very near to me, is very good friend of me also. Salim sir has already defined plea bargaining very well. There are lots of definition as given by the sir. Then sir has talked about the US system, because it came from the US, and about the pendency, and how in US the system works, and how the 3,000 cases out of 3,2700 cases was comes under plea bargaining, and only 300 cases went for the trial. Now, if you look at this situation right now, because we all are in a COVID situation, so we entered in one of the most unprecedented crises of our times. Now, the price paid in human lives has resulted in greater demand for justice these times. Now, coming to some of the facts, I want to say some of the facts first, then come to the plea bargaining. Now, in India, if you look at, we have 1,600 law colleges and around 1.5 million advocates. And if you look at the number of advocates, most number of advocates in UP, it's almost 3 lakhs. And the second number, the second number is Bihar. So in Bihar also more than 1.5 lakhs advocates. Now coming to the number of judges, now we have total 17,000 judges we have right now. And if you look at the per million population, the need of the judges, we need 50 judges per million population. Now, we all know the India's population, which is pegged at 1.3 billion. So applying this benchmark, India should have approximately 70,000 judges we required right now. Now, what is the number of judges right now? It's approximately, you can check on the Google also. So right now, if you look at the number of judges, we required more than 70,000 judges. But look at the number of judges in India. Right now in subordinate judiciary, if you look at the district courts, that we said trial courts, there are 17,000 judges in subordinate courts. And if you look at the high courts, all the high courts I am talking, there are 600 judges right now in the high courts. And if you look at the Supreme Court, 31 Supreme Court judges we have. So if you calculate all this number of judges, still it's not counted to 70,000 judges. That's we required. Now coming to the pendency, because we all know this plea bargaining, why this plea bargaining came, what is the object of plea bargaining, why plea bargaining was introduced in the CRPC chapter 21A, section 265A to 265L. Now if you look at the number of cases, more than 3.5 crore cases are pending. Now it's a big number. Look at the number of cases, it's a big number. But in this 3.5 crores cases, 60% cases are related to civil matter. Now, 60% are the civil in nature, so only 40% cases are of criminal in nature. Now, there is another fact about the under trial prisoners, as Rakesh sir also speak about the under trial prisoners. So coming to the number of under trial prisoners, in UP only, the whole number of under trial prisoners I'm talking, the 22.3% under trial prisoners are in only in UP, and which is followed by Bihar. Again, 8.3% under trial prisoners in Bihar. So they all are under trial prisoners. Now they all go for the trial, and we know that the number of times, number of years, how much time it will take in a trial, especially in a criminal trial, or you go for a civil case. Now we have for this all to pass out this delay and to enforce this mechanism quickly, we have drafted our CRPC in 1973. Earlier we have CRPC 1898. If you remember 1898, there is no provision for plea bargaining. Only there is a provision of an accused for plead guilty. Before trial, before the start of the trial, if the judge asks you either you plead guilty or innocent, if you plead guilty, then there is no need of trial also. If the court, if the presiding officer thinks fit, then there is no need of any trial. Now, if you look at the CRPC, Code of Criminal Procedure 1973, it provides a mechanism for the enforcement of criminal law. It just provides a mechanism. Now, we need a necessary mechanism. It's like a machinery for the detection of crime, for the arrest of suspected criminals. Then we have the collection of evidence. Then for the determination of guilt or innocence. And then at the last, we have imposition of proper punishment. For all these, we have CRPC, Code of Criminal Procedure. That's our general procedural law. And if all this machinery, if there is no machinery, then if you look at substantive law, it becomes worthless. If there is no procedural law, then the thieves, then murderers, rapists, dacoits, they are not detected, they are not prosecuted, they are not punished if we don't have the CRPC. And if you look at the expenses also, that the object of the CRPC, when we draft the CRPC in 1973, after the Law Commission suggestion and all, it should not be more expensive. Then there is no delay in the process. And whatever we applying in the procedural law, if there is a lot of delay and there is more too much expense, then if you look at your penal laws, it should be it becomes useless. It becomes unoperative. It is very oppressive and it becomes useless. This penal laws. The penal laws I'm talking about, the substantive law. This Indian Penal Code is a general substantive law. There are lots of substantive laws we have. The special substantive laws also, substantive criminal law. Now, if you look at this, coming to the history part of the plea bargaining, sir has already mentioned about the 142nd Law Commission report that came in 1991. If you look at Law Commission report, 142nd report, it mooted the idea of concessional treatment. It doesn't specify about the plea bargaining. The idea of concessional treatment of those who plead guilty on their own volition, but it was very careful to underscore that it would not involve any plea bargaining or haggling with the prosecution. Now, that the same with the Justice Malimat Committee report on the criminal justice system. If you look at the Justice Malimat Committee report 2003 on reforms of the criminal justice system, which endorsed the various recommendations of the Law Commission with the regard to the plea bargaining. Now in India, this concept was not part of the law until 2006, because in criminal law 2005 amendment, criminal law amendment 2005, it was introduced first time. And if you look at the enforceable date, it was enforced on in July, some date on 5th July, I think, in 2006. And there is another important reform, this 2006 also in July, central government come with a notification and make the rules about the socio-economic offenses. I will come later on the socio-economic offenses, what socio-economic offenses are and why it is very important here in this plea bargaining. So there has always been a provision in the CRPC for an accused to plead guilty. That's what I'm saying, before trial. But instead of claiming the right to full trial, it is not the same as plea bargaining. If an accused plead guilty before the trial, then there is no need of a trial. Now, if you look at the plea bargaining also, this is also before trial. Now, the disposable of the cases by this method of plea bargaining is an alternative method to deal with the huge arrears of criminal cases. We all know the number of pending cases. So it is really a measure and a redressal as the same it has been brought on a statute. And it has also added new dimension in the realm of judicial reforms, you can say. But unlike the US system, as Sir said about the US system and the other countries, where the prosecutor plays a key role in the bargaining with the suspected offender, in the Indian code, this CRPC makes plea bargaining a process that can be initiated only by the accused. That is one problem. At the end, I will come to the problems of this plea bargaining. Why in India this plea bargaining is not very successful? Why people are not applying? Why the accused person didn't go for the plea bargaining? Now coming to the mechanism, because our topic is about the mechanism. So look at the mechanism. If you look at the mechanism of this plea bargaining, now there are certain offenses on which this chapter shall not apply. Shall not apply. There is no may. Shall not apply. Now, what are the offenses? What are the other aspects where this chapter is not applied? The plea bargaining will not apply. The first one is if the offense where the punishment is death penalty, offenses where the punishment is life imprisonment, and the offenses where the punishment is more than 7 years imprisonment or 7 years. Offenses where, in simple words, offenses where the punishment is more than 7 years, this plea bargaining, this chapter will not apply, shall not apply on the offenses where the punishment is 7 years or more than that. That is the first. Second exception is the offenses affect the socio-economic condition of the country. If the offenses affect the socio-economic condition of the country, this chapter will not apply. Now, next is where such offenses have been committed against women or a child below the age of 14 years. Even if you look at the section 265L of the CRPC, it states that it doesn't apply on the Juvenile Justice Act that we call JJ Act. So a child below 14 years of age, it doesn't apply on the JJ Act or a child or offense against women. And there is another, if the accused is a previous convict of such an offense, the same offense where he was applying for the plea bargaining, he cannot apply. Where the accused is a habitual offender, he or she cannot apply for the plea bargaining. Now, when it apply, where it apply, how you will apply this for plea bargaining? Coming to that, if you look at section 265A, when the charge sheet is submitted, by the police under section 173 subsection 2 of the CRPC, when the charge sheet is submitted by the police, you can apply for plea bargaining. Charge sheet means simply the investigation report. The final report of the police is called the charge sheet. And before that, when you file an FIR, only on an FIR the charge sheet is filed. Now, the another method, when your FIR is not filed, then another method is you can go for a criminal complaint. So another method is, another where you can apply for plea bargaining is when the cognizance is taken by the court at the magistrate, and there is an issue of process under section 204 of the CRPC. Cognizance is taken under section 190 of the CRPC, and this issue of process under section 204. Issue of process simply means either summon or warrant. When the court has already issued summon and warrant to the accused person, then you can go and apply for plea bargaining. Now, to file the plea bargaining, this application of plea bargaining, only where the case is pending for trial. So these all process, the filing of charge sheet and cognizance is before the trial. Then the accused has to submit an affidavit, okay, where it is mentioned that it is he or she is voluntarily preferred to go for plea bargaining, and then the court will issue a notice to the public prosecutor or the complainant. Public prosecutor in the case of the charge sheet, when the charge sheet was filed, and complainant when a private complaint, criminal complaint was filed. And then it was examined by the court of the accused in camera. So this proceeding in camera, the examination of the accused, where the accused is, whatever it is saying or whatever the application has said, it is voluntarily or not, where it is voluntarily preferred or not. Then after court satisfaction, the court will provide a time to the public prosecutor to work out a mutually satisfactory disposition of the case. Now, mutually satisfactory disposition of the case, it may include compensation to the victim or other expenses to the victim. And there is the court has to see that there is a genuine terms of settlement. So it's a settlement process between the accused and the complainant or the public prosecutor. Now, if you look at the punishment of the after plea bargaining, when the court will grant plea bargaining, and if you coming to the judgment, that's coming to the open court, then the court will give the punishment. Now, punishment, if you look at section 265E of the CRPC about the punishment, if for example, if it's an offense of theft, we all know the maximum punishment is 3 years, but it's not, the minimum punishment is not defined. So where it is defined such minimum punishment, or the court can grant a minimum punishment, court will take half of the minimum punishment or 1/4 of the minimum punishment court can give, as the case may be. Now another thing is, there is no appeal when the court has given the judgment after the plea bargain, but after the application of the plea bargaining, and the court satisfied that this is voluntarily given by the accused, then when the judgment is given, when the order is passed by the court, against that order, against that judgment, there is no scope for appeal. So you can't go for appeal after plea bargaining. Once you go for the application of plea bargaining, you can't go for appeal. Now, the only process, if so, for example, if some miscarriage happen, misjustice happen, then the only process you can go for SLP, special petition under Article 136, and you can go for writs under Article 226 and 227 to the High Court. Now, whatever the statement given by the accused portion will not use for any other purpose other than this chapter, that means this plea bargaining. So whatever the statement of the accused, it will not use for any other purpose. That means if your plea bargaining application was failed and for some reason it was dismissed, then whatever the statement by the accused, it was not used for any other purpose as an evidence. Now, coming to the difference between US and India, in US, if you look at the US system, that's this plea bargaining we came from in US. But if you look at this US system, there are 3 types of plea bargaining, as Rakesh rightly said: this fact bargaining, charge bargaining, and sentence bargaining. But look at in India. In India, we have only sentence bargaining. There is no fact bargaining. There is no charge bargaining. That is another problem in plea bargaining. Now, coming to the problems, why accused is not going for plea bargaining? There are certain reasons. Now, first is like advocates. We all know advocates never went for the plea bargaining. They want to they want this criminal cases or the civil cases go for longer time, the delay, then they will earn. That's they're earning. So that's one thing. Advocates, most of the advocates, they don't want to go for the plea bargaining. Even some of the advocates, they don't know about this plea bargaining. Unawareness is very aware. They are not aware. Now the accused person, look at the accused persons or the people of this country. Most of the people, they don't aware about this plea bargaining. If you go to any person, any friend and said about this plea bargaining, they said no, ऐसा तो नहीं होता है, ऐसा कहाँ होता है criminal law में. Okay, so they don't know about this plea bargaining concept. Third, the problem with the plea bargaining is you always go, after application of the plea bargaining, if the court has given a judgment, you always a guilty person, a convicted person. You will not be released. You will not be an acquitted person. You always a guilty person, a convicted person. That's the difference between this compoundable and all. So that's the problem with the plea bargaining. You always a guilty person, convicted person. Now here only we have the bargaining on sentence. We have not go on bargaining on fact and the charge. So in India we have only sentence bargaining. That's another problem with the plea bargaining. Now we all know the delay in procedure. So accused portion, they all knew that okay, we can delay the procedure. It will go for 10 years, 20 years, and whoever the complainant, he forgot about the case, no evidence will come after 10, 20 years. We have seen in so many cases. You can see number of cases where there was a lot of delay, and due to delay in the procedure, the complainant forgot about the case. Even you forgot about the case, then your next generation will come and fight for your case, and he will also forget, because 10 years, 20 years, 30 years, it will go on and on and on and on, because there is no time duration given for the trial. There is no time duration given for the investigation. That is the problem in the CRPC, that there is the new criminal law reform is coming. Next problem with this is, if you look at the scope of plea bargaining, it's very limited. Very less number of offenses are covered by the plea bargaining. Offenses were less than 7 years, and it's not against the offenses where it go against the women or the children under 14 years. So the scope is very limited. That's another problem. Now another one is the last problem I have seen, that conviction rate. Now in India, if you look at the conviction rate, it's very less. So we all know, if I, for example, if I am an accused person, I'm a murderer. So I know that I will not, I'm not going to be convicted, because I know I will release one day. I will manage all the evidence. I will manage the witness, everything. And that's why in India, the conviction rate is very less, if you look at. So at the last, in the concluding section, I can say that this concept of plea bargaining, if you look at, it's not entirely new in India. Now, if you look at the section Article 20 Clause 3, which speaks about this in the Constitution, which prohibits self-incrimination. So that concept is already. I think I have already. This time is over, I think. So I'm just 1 second. So therefore, the need of the hour is not a substitute for trial, but an overall the system, which can be in the terms of the structure, composition, and its work culture. So all these measures would ensure reasonably fast trials. Thank you, sir. Thank you for giving me an opportunity.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you, sir.
Thank you, sir. Thank you.
Thank you, sir.
Thank you, sir.
Thank you.
Thank you, sir.
अब हम सादर आमंत्रित कर रहे हैं, सादर और सस्ने डॉक्टर अमित कुमार श्रीवास्तव जी को, डिप्टी डीन फैकल्टी ऑफ लॉ स्टडीज, मेवाड़ यूनिवर्सिटी, चित्तौड़गढ़, राजस्थान।
थैंक यू सर। मेरी आवाज सुनाई दे रही है?
हाँ, दे रही है।
ओके सर, थैंक यू। First of all, I thanks to Dr. Jain Kumar ji, Director of SKJ Law College, Muzaffarpur, who invited me for this webinar. I thanks to Dr. K.K.N. Tiwari ji, Principal of SKJ Law College, and Dr. B.M. Ajad ji, Vice Principal of SKJ Law College, Muzaffarpur, Bihar. And I thanks all of learned speakers, students who are present and assembled here. Learned speakers have greatly benefited all of us. I will briefly present my points to you because time is binding. Topic of the webinar is mechanism of plea of bargaining in criminal justice system in the context of COVID-19. I divided this topic into three parts. First part is what is the mechanism of plea of bargaining, and second part is what is the criminal justice and it is relevant in the period of COVID-19. Now we will first understand what is the concept of plea of bargaining. It was introduced through the Criminal Law Amendment Act 2005 based on the recommendation of Law Commission of India. Plea of bargaining refers to pre-trial negotiation between the defendant through his or her counsel and the prosecution during the accused agreed to plead guilty in exchange of lesser punishment. It is a contractual agreement between the prosecutor and defendant. However, it is not enforceable until a judge approved it. Thus, a new chapter 21A of plea of bargaining has been included in the CRPC 1973, and that chapter come into effect from 2006. And plea bargaining is an agreement in a criminal cases between the prosecutor and defendant, whereby the defendant agreed to plead guilty to particular charges in return for the sum of concession for the prosecutor. This means that the defendant will plead guilty to a less serious charges or to one of the several charges in return for the dismissal of the other charges. Or it may mean that the defendant will plead guilty to the original criminal charges in return for a more lenient sentence. A plea bargaining allow both parties to avoid a lengthy criminal trial and may allow criminal defendant to avoid the risk of conviction at trial on a more serious charges. Plea bargaining was considered a predominant American phenomenon during the 1970s, but has since spread throughout the world. In the period of lockdown due to COVID-19, the impact on one and all. The court are no exceptions to it. While many courts are not working yet, some others are hearing only urgent and important matters. Even the Supreme Court of India has been hearing only important cases through video conferencing. The Supreme Court of India has ordered to the state to form high power committee to evolve measures that will solve the problem of the under trial possibility contracting the virus. The court further suggested that the under trial involvement of the cases, the prescribe a minimum 7-year punishment may be resolved on interim bail for a suitable period of ensure that they do not contract the virus which is in the prisoners. This was done in the last month of March 2020. Khadak Singh, which the case is related to right of privacy, under Article 21. Article 21 is that no person shall be deprived of his life or personal liberty except according to procedure established by law. Here, the meaning of life is not subhuman life; it is a healthy life. These are being violated during the health emergency, and it is need to take an initiative to reduce a load of our court and dispose of cases to ensure that would not be under the burden of the cases which court open. Hence, the concept of plea bargaining may come handy. Plea of bargaining shall be available to the accused charge of an offence punishable imprisonment up to 7 years. It does not apply when such offences is affecting to socio-economic conditions of the country or has been committed against a woman or a child below the age of 14 years. The parties are given time to work out on MSD. The meaning of MSD is mutually satisfactory disposition as per the prescribed procedure, which may include giving compensation to the victim by the accused and other legal expenses incurred during the pendency of a case. Where mutually satisfactory disposition of the case has been worked out, the court shall dispose of the case by sentencing the accused to 1/4 of the punishment provided on extendable as the case may be for such the offences. And the statement or fact stated in application of plea of bargaining shall not be used for any purpose other than the plea of bargaining. The judgment delivered by the court in the case of plea of bargaining shall be final, and no appeal shall lie in any court against the such judgment. Plea of bargaining as a ADR mechanism provided benefits of the victims, like he or she can easily get compensation, avoid long-drawn judicial process, less time and money consumptions, and benefit to the accused, like avoid long-drawn judicial process. He or she will get half punishment in case of minimum punishment, may be released on probation or admonition. No appeal lies against the judgment in favor of him. Now we talk on second point of the webinar, that is the criminal justice system. Criminal justice is a delivery of justice to whom committed against the crime. The criminal justice system is a series of government agencies and institutions. Goal includes and rehabilitation of offenders, preventing the crimes and mutual support of the victims. The criminal justice consists four parts, which are as follows. First is law enforcement agencies. Usually it is the police, public prosecutor and defense lawyer, judges, agencies for detaining and supervising of offenders such as the prisoners or probation agencies. In the criminal justice system, these different type of agencies operating together as a principal means of maintaining the rule of law within society. Many of my friends who are currently working in judicial officers and hold posts ACGM, CGM, and judicial magistrate, when I talk to him, it has come to know that the application of plea bargaining cases are continuously coming under Section 265B of CRPC 1973. But the main problem is also facing social distancing. At present, the police is not doing its work properly. Investigations done by the police. Police is also an important part of the criminal justice system. Whenever crime occurs, first of all, FIR is written and evidence is gathered. In the period of COVID-19, the police are not following social distancing rules. The role of police is very highest in criminal justice system, but it is not able to play its role. Most of the police person do not know how to run a computer or smartphone. The same problem occurs with public prosecutor and defense lawyers. In the period of COVID-19, police are not following DK Basu versus State of West Bengal AIR 1996 Supreme Court case guideline, which was held by Supreme Court. Recently, in all over India, there was a night curfew, but the police and public did not follow it well. The task of controlling the public is both to the government and the police, but it could not be do its job. Our criminal justice system is completely failed due to non-functioning by the police and government. Even today, Epidemic Disease Act 1987, Management Disaster Act 2005, Section 188 of IPC are applicable and enforced, but the police system are not following it, nor they are getting it done. They are using arbitrary power and generally violated the Article 14, 20, 21, 22 of the Indian Constitution, and they feel that they are bigger than the laws of the country, and no one has control over them. This is a very bad for our country. In conclusion, we can say that if the criminal justice system become good for us, the concept of plea of bargaining can be more useful and beneficiary for us. According to Abraham Lincoln, discourage litigation, persuade your neighbors to compromise whenever you can. As a peacemaker, the lawyer has superior opportunity of being a good man. By following the concept of plea of bargaining, in the period of COVID-19, plea of bargaining has given many advantages, such as the court that trial will end soon, the public prosecutor and defense counsel will not have to collect the evidence, nor will have the summon to witnesses. In the present time, the coronavirus infection will not go away, the disease will not progress, and people will be healthy, and plea of bargaining will save both time and money, and social distancing will also be easily followed. I express my gratitude to all of you who are present and assembled here. You listen to me carefully, so I thank you very much. Thank you, sir.
Thank you, sir. Thank you.
Thank you, sir.
Thank
वेरी
you.
मच अमित कुमार जी।
Thank you.
अब हम सादर
थैंक यू सर।
और शासने सुभाष चंद्र राय जी को, डॉक्टर सुभाष चंद्र राय, डीन रिसर्च एंड डेवलपमेंट, चाणक्य नेशनल लॉ यूनिवर्सिटी पटना। सुभाष चंद्र राय जी। किसी कारणवश सुभाष चंद्र राय जी कनेक्ट नहीं हो पा रहे हैं। अब हम जो पार्टिसिपेंट्स हैं, जो इस लॉ कॉलेज के स्टूडेंट्स हैं, उनसे ये कहना चाहते हैं कि इस संदर्भ में जो टॉपिक है मैकेनिज्म ऑफ प्ली बार्गेनिंग इन क्रिमिनल जस्टिस सिस्टम इन द कंटेक्स्ट ऑफ कोविड-19, इससे संबंधित कोई भी प्रश्न हो तो कृपया हाथ उठाकर वो पूछें, बताएं अपने क्वेश्चन को। Thanks.
Hello, जी सर।
Thanks. Okay, sir. अमित श्रीवास्तव सर, बहुत दिनों के बाद आपसे मुलाकात हो रही है।
थैंक यू।
Thanks. Okay, did you recognize me? Your delivery was highly excellent.
Yes.
Thanks,
You are
sir.
principal of SKJ Law College, sir.
Okay, sir.
Thank you, sir. Thank you.
Once upon a time, we were functioning along with each other. Thanks, sir. Once Mark Twain, a US thinker, said that compromise is the best and the cheapest lawyer. And I think our legal luminaries has expounded the topics of today, plea bargainings on the principle that, thanks sir, we the college family members are highly joyful that our institutions had organized the today's webinar on the topic mechanisms of plea bargaining and criminal justice system in the context of COVID-19. Our distinguished orators have explained the trial provisions of CRPC detailed under Chapter 21 from Section 265A to L. interlinking with the today's biggest and chronicle threat of COVID-19 crisis across the world, I extend my thanks and happiest and heartiest thanks to our esteemed speakers, Dr. Salim Javed sir, Head Postgraduate Department of Law, Patna University, Dr. Rakesh Kumar, Assistant Professor, School of Law, Christ, Dem to University, Delhi NCR, Dr. Amit Kumar Srivastava, Deputy Dean, Faculty of Legal Studies, Mewar University, Chittorgarh, Rajasthan, and yes, sir, Dr. Subhash Chandra Rai, sir. Do you listen to me, sir? Do you listen to me? Audio is. Sir, would you like to express your vision? Sir, do you listen to me? आप सुन पा रहे हैं? सुन पा रहे हैं? तो once again,
yes, sir.
Please proceed ahead, sir. Please proceed ahead. We are so desirous. We are eager to listen to you. After a long period of time, we are meeting. Once upon a time, we were the students of the same institution. Sir, proceed.
Yes, sir.
आप unmute कर लें, sir. Please remain on mute and we can proceed ahead.
Okay, sir. Thank you. Thank you. Thank you, Professor K.K. Tiwari.
Thank you, sir. Yes, thanks. Some technical difficulties by which you are not being connected. Please proceed ahead, sir.
Yeah.
I shall conclude my vote of thanks. Specific, I shall convey to you my sincere thanks. Please proceed ahead, sir.
Okay.
Thank you, sir.
Respected. Hello.
इस बात के लिए थैंक यू।
Hello.
Yes, please, sir, proceed.
Respected Dr. Jain sir, Professor Jain sir, Director of the SKJ Law College, Muzaffarpur, and Principal Dr. K.K. Tiwari. Thank you for giving me this opportunity. In the outset, I would like to say a mechanism of plea bargaining in the COVID time, coronavirus disease of 2019. All are aware, the whole world has kneeled down this pandemic period. And you see that the prisoners, the condition of prisoners, the plight of prisoners, one can understand very easily how they might have been suffering. Especially those who are under trial prisoner, as well as those who are convicted also. We know very well that our jails are crowded. The rate of crime is increasing. And this disease is spreading everywhere. Because we are the carrier of the disease, virus. So, in this pandemic period, this is a very significant period in which we can revive the concept, or you can say we can make the people aware as well as propagate among our judicial fraternity for the implementation of the plea bargaining concept. Plea bargaining concept, it has been introduced by Justice Malimat in 2006. And this plea bargaining, it is common, in practice in United States of America, and many people are, they are being punished also, as well as there is a minimization of the crowd in the jail, and people are getting benefit. So that's why the concept of plea bargaining was introduced in India also by creating or by amending CRPC chapter 21 capital A. and it has been added section 265A to L. So now you see that why this concept came or emerged all of a sudden. It is not a, all of a sudden it has emerged, rather a chance that the Tablighi Jamaat, we know very well that they had congregated in a religious ceremony in Delhi and they had been arrested. And with the help of this plea bargaining, they were released by paying some fine, and now they are to their own country, their own residence. So this concept has emerged that why not the concept of plea bargaining be applied to our institutions, to in this country, everywhere. Why not judiciary should take care of? Whereas you see that even the Supreme Court directives is also that we should take care of that our courts, our jails should be, the burden of the crowd should be minimized, and therefore the Supreme Court is also positive in this concept. Even you see that we have a provision under section 360 of the CRPC. We have the provision, that provision is of probation, that those who have a good conduct, they can be released on probation, on bail for certain period. And later on, when the pandemic will be over and the situation, okay, they can be brought again to the jail. So especially for the under trial prisoners, this plea bargaining will be of a great help. Here, the concept of the plea bargaining, we know very well that this is applicable to the person who is charged of offenses not more than 7 years of imprisonment. Those offenders who have life imprisonment more than 7, or those offenders who have a death penalty, maybe possibility, they do not come under this plea bargaining concept. If you take the literal meaning of the term plea bargaining, bargaining does not mean negotiation or counter negotiation. Rather, plea is here very significant that it means emotional request. A convict will request the honorable court emotionally, make a statement that he wants to confess guilt. And so after confession of the guilt, the court will send a letter to the prosecutor, to the investigator, as well to the victim or the other person related to. And after the discussion in camera, they will come out and then there will be negotiation. They can be released on half of the punishment. If they accept their guilt, they may be punished. If there is a fixed punishment, then 50% of that punishment they will serve in the jail, or if there is no such fixed punishment, then 1/4 of the total imprisonment they will suffer. And in this way, they can really get released. Here, the burden of the court will be minimized, and even on punishment, some fine that can be released. So burden on the court will be minimized, and speedy trial procedure will be also there. So how these procedure can help in the pandemic period? The plea bargaining concept, you see that the convict person can meet the lawyers, and with the help of the lawyer, the petition can be filed before the court under section 265 capital A, and later on the procedure will move. So it's a very simple procedure in which the court will have minimum hours as well as other expenses, as well as the person who is convicted will have a good health. He will also suffer less and less. There will be speedy trial, and the society will also serve something. Society will think that at least some the accused person has been convicted. Otherwise, years and years the cases go on, and what happens ultimately? They are released from the jail. So the victim, there is no victim, remedies to the victim. So in this way, this is a mechanism that at least the victim will get something. As well as the jails will also be loosened from the burden of the crowd. Otherwise, this coronavirus, it is going to affect, because wherever there is a crowd, it will spread more and more. And also those who have been convicted, they can be taken recourse with the help of section 360 of the CRPC under probation of Act 1958. So in this way, the pandemic situation has brought our mind towards the remedies in this field, that we can create an environment for the social justice cause, for the cause of the victim as well as cause of the convicted person or accused person. All these will be benefited, even the judiciary will be benefited, and the society will get relief. The family of the victim will also get relief. Although there are some counter arguments also that jail is the better place. If they are released and come to home, they will again have corona disease. It is not so. Everyone knows that jails are overcrowded, and it is very difficult to separate them, make each and every one cell or one room. It is very difficult. So therefore, this COVID period has given us a situation that this plea bargaining concept may be applied, enforced properly, and we can have a good justice to the victim as well as to the convicted person also. Thank you.
Okay, sir.
Hello.
Thank you, sir.
Thank you, sir. Really?
Thank you, sir.
No one
सर मत बोलो इतना थैंक यू
really men of letters. To our respected and distinguished faculty members, Dr. Salim Javed sir, Head Postgraduate Department of Law, Patna University, Dr. Rakesh Kumar, Assistant Professor, Government Law, Dr. Avinash Kumar, Assistant Professor of Law, Vice Dean to University, Delhi NCR, Dr. Amit Kumar Srivastava, Deputy Dean, Faculty of Legal Studies, Mewad University, Chittorgarh, Rajasthan, and our Dr. Subhash sir, Subhash Chandra, Research Development, Chanakya National Law University. Your remarkable and extraordinary focus on the topic of today. I express my extreme pleasure and sincere thanks on behalf of the institution as well as on my behalf also for your impressive and informative delivery. We are highly thankful and grateful to Sri S.K. Misra sir, Honorable President of the College, and Dr. Srimati Ujwala Misra, Madam Secretary, for their gracious directives and ongoing continuous encouragement to organize such academic programs. Thanks to our management. I am thankful to our director sir, Professor Jayant Kumar, whose efforts and endeavors are learning for the youngsters like me. I am thankful to my elder brother, Professor Braj Mohan Azad, Vice Principal, whose nice full performance to conduct the program. I extend my thanks to the distinguished faculty members remaining online and offline, Professor Prabhat Kishore, Dr. S.P. Chaudhary, Professor P.K. Sudan, Professor Astha Suman, and all the faculties members to make the program success. I convey my thanks to our non-teaching employee and technical staff like Rakesh Kumar, Ujjwal Kumar, Ajit J, Vivek Kumar, and so on, as well as to the press and media employee for their made honest and best effort for the success of the program. I forward my thanks and blissful blessings to our endeared students for their patient and peaceful listening. I do expect once a day, dear students, you would get your highest destinations. I want to conclude my vote of thanks having reciting 2 lines written by Vishwakavi Gurudev Ravindranath Tagore. Please, with your kind permission, I would like to read it. Where the mind is without fear and the head is held high, where knowledge is free, where world has not been broken up into fragments by narrow domestic walls, where the words came out from the depth of truth, where tireless striving stretches its arms towards perfections, where the clear streams of regions has not lost its way into the dreary desert, sand of dead habits, when the mind led forward by thee into the ever widening thought and actions into the heaven of freedoms. My father, let my country awake, let my country awake. Thanks once again to all of you. Thanks, sir.
Thank you, sir. Thank you.
Sure.
Thank you very much.
अब हमारा रिक्वेस्ट है हम सब लोग to honor our national anthems, please. You would help reciting national anthems. Thereafter, programs be concluded finally. Please begin, sir. जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा हिंद हिमाचल चल जलति तरंगा जब शुभ नाम जागे तब शुभ मंगलदायक जय हे भाग्य विधाता जय हिंद
जय हिंद
जय हिंद
जय हिंद भारत माता की जय
भारत माता की
जय